and also going live.
Okay.
Just a moment, sir. Good evening, one and all present here. I am Monalisa from ClearNet, the designated section assistant for the seamless experience. ClearNet is India's most trusted and widely used digital platform offering multiple enriching services exclusively for doctors. ClearNet is very delighted to be a part as a digital partner for this event organized by Tamil Nadu Ophthalmological Society, and today's session is all about TNOA towards excellence, medico-legal insights. So thank you for your patient listening, everyone. So let us get started with today's session, to which I would like to invite the President of Tamil Nadu Ophthalmic Association, Dr. T. Nirmal Frederick. Over to you, sir.
Thank you. So good evening, everyone. It's indeed a great pleasure to welcome all of you to this World Sight Day special webinar from Tamil Nadu Ophthalmic Association. And today we have a wonderful session, again TNOA Thursday. Welcome to this webinar. I invite all our members and thank you for joining us, Dr. Sujata Mohan, the Vice President, the Secretary, Dr. Sriram Gopal, and all the members of the Managing Committee of Tamil Nadu Ophthalmic Association, and the members of the Medico-legal Committee of TNOA, Dr. Murli, Chairman, and Dr. Satyan, Convener, and Dr. Madhavan, and all members of the Medico-legal Committee, and MC members, and all the panelists. Thank you all for joining today, and it's indeed a great pleasure to welcome you again for this webinar. A quick recap of what we have done for the last month, and so this is the year following our Platinum Jubilee, and we've been focusing on our Platinum subjects. And we started with the first webinar actually started with the same committee, Medico-legal Committee, to empower our members and inspire confidence in practice. And this was the session at TriCon 23, followed by the first webinar where we covered a lot of subject relevant to ophthalmic practice. And today we have lined up another interesting webinar with important aspects. And this was our first session. And then we had this Young Ophthalmology Task Force webinars, which was very well attended by close to 1,000 odd members now. And the second session also focused on innovation. We had the inspiring talk by Dr. Suvan and many presentations from our youngsters. And the TNOA Insurance Committee is doing a commendable job. So we met at SN for the preliminary meeting, followed, and of course, our initial meeting at TriCon, and had a series of discussion. And this is now becoming a major challenge for all of us. And the insurance committee and met and decided on a few basic rates that our members can follow. So this has been circulated to all our members, and I request members to go through our advisory and follow this diligently so that TNOA would be able to help our member hospitals as well. Please do not quote under this rates, and also be careful while negotiating the contract and before signing the terms and conditions. The nursing home board has given a advisory to the members of the nursing home board not to sign any agreement till the scientific rates are presented and approved by the State Council, as well as the talks are on with the General Insurance Council. The General Insurance Council has invited our representatives. So myself and Dr. Sriram, our secretary, would be attending this GIC meeting at Mumbai on 18th. We will update you on the deliberations. September also saw eye donation fortnight being celebrated by many of our members and institutions, We also had a webinar organized by Dr. Sharmila Devi and her team. It was an enlightening session on lamellar keratoplasties and the advances. So thank you, Dr. Sharmila. We also had the eye donation fortnight. Thanks to our Vice President, Dr. Sujata and Rajan Eye Care for inviting, and this was a wonderful celebration there. Thanks to our ARC team, we had our first ARC meeting at Kanjipuram. It was a very well attended full hall session at Kanjipuram. So thanks to the Kanjipuram District Ophthalmic Association. And followed by that, we had a wonderful session on quality and infection control organized by the TNOA Quality and Infection Control Committee and Coimbatore Society of Ophthalmic Surgeons. It was very well attended and very well organized by the team, and over 200 participants was part of this deliberations, where we were able to impart education and on infection control to our members. We also had this interesting session organized by the ARC team again at Pegasus TNOA Leadership Development Program. This was the first initiative by any state society across India. AO has been organizing this every year, but this is the first time a state society is doing this. So thanks to our members and teams for participating. Over 30 members participated in that two-day event. We also collaborated with the physicians associations, GCDC collaboration, and did a fundus workshop for the students of medicine and other specialties. It was a very well organized fundus simulation session, actively participated by Dr. Prasanna and few of our members. I was also happy to participate in the panel discussion on perioperative challenges in cardiodiabetic patients. And then I also participated in the TOSCON 2023, the 9th edition, as your representative, and it was a wonderful celebration of academics as well as detailed workshops. We were also able to honor Dr. AK and Professor Krishnadas with oration. I also like to congratulate our immediate past president, Dr. RK sir, for being awarded the NM Sood oration at the recently concluded GSI conference at Pune. And just to update you on today's event, myself, our TNOA Advocacy Task Force Chairman, Dr. Mohan Rajan and Dr. Ravi Shankar, met the Health Minister and gave a representation on behalf of TNOA. This is our advocacy initiative to have separate daycare category for eye centers, which is not available in TNOA in Tamil Nadu now, and also optimize the regulatory requirements, particularly the exemption of B-scan from the PCP and DT Act, and optimization of fire safety requirements for daycare centers, and also proper eye checkup for commercial drivers. We all know most of the drivers have suboptimal vision, and we need to, and the regulatory requirement for the certification is very poor. So we emphasize the need for that, as well as myopia is becoming epidemic proportions. So we have to mandatorily screen children before preschool. So these are the focus areas. We gave a memorandum to the health minister, and he has promised that he will take up the issue and work and help us meeting the healthcare officials. So that is the update from TNOA for all of you. And today I'm happy to welcome you to the second edition of Medico-legal Insights. We have wonderful speakers, expert speakers in their own right. So I am happy to hand over the session to Dr. Murli Ariga. Before that, I invite a few insights from Dr. Sujata Mogan, our Vice President, and the other leaders. So then we move on to the session.
Thank you, Dr.
Over
Nirmal.
to you, madam.
Thank you, Dr. Nirmal. I think the era where my father was practicing, medicine was considered as a noble profession, and doctors were unquestionable. But I think now everything has changed, and the patient-doctor relationship has also changed, and we are no longer unquestionable or infallible. So the most important thing is, and also because there is corporatization of healthcare, this is again one of the recent setbacks why people have started looking at doctors as business models rather than people who serve the community. So the most important thing would be to protect ourselves. And probably this is one of the webinars which is going to teach us how to protect. That is the best way to handle any medical legal case, is to prevent it. So how to prevent it, and if you do come across a medical legal case, how to handle it. I'm sure with some of the speakers who have got so much of experience, we're all going to learn a lot. And thank you for the opportunity.
Thank you, madam. So we move on to the session. Dr. Murli Ariga is the chairman of the TNOA Medical Legal Committee, and Dr. Satyan is the convener for the committee. I hand over the academic session to them. Over to you, Dr. Murli.
Thank you, Dr. Nirmal, and thank you, Dr. Sujata Mohan. I think we're actually enjoying the academics and the sessions and the programs organized by the TNOA for the last several months now. And the previous president doing a lot of academic activity. And I think we're now seeing a lot of activity from the current dynamic, very young and dynamic president, Dr. Nirmal, I think a very close friend as well. I think without much ado, I think we should get started as far as the medical legal aspects of practice is concerned. I think as Dr. Nirmal mentioned that we have started our journey into understanding and sort of deciphering the law and understanding how it applies to ophthalmic practice. We had the webinar, we had a physical meeting in TNOA, and also we're now continuing to start to educate ourselves as well as our members and our colleagues regards to safe practice, regards to understanding the law and preventing litigation and various aspects of the new regulations that are in the anvil, new regulations that are threatening to come in and interfere and sort of affect us in our practices and so on. So we can no longer hide under the so-called notion that we don't know the law, we don't understand the law and all that. We need to understand the very basic aspects of practice. Today we have put together a few talks and topics which are very relevant to day-to-day ophthalmic practice. And in this, we have a very important initiative taken by the TNOA, and with a lot of hard work put in by my colleague and convener, Dr. Satyan. He has actually put together a booklet on informed consent on various aspects of what information should be given to a patient before a procedure or surgery is undertaken. What is the information that should be provided, bilingual, give some time for the patient and relatives to understand, let it sink in and then do the procedure. Don't be in a hurry. So he's going to talk about informed consent and the TNO initiative as to how we have gone forward on that. And then I'm going to speak about understanding the generics and the newer regulations that are probably being proposed by the National Medical Commission. And we also have the new threat of having a different equation between the doctor and the pharma companies and the sponsorship with regards to conferences, meetings, our relationship with the pharma industry and how to proceed. So we have a very interesting talk which is going to be delivered by Dr. Madhavan, who has been office bearer of the TNOA and is well known to all of you. And I would like to introduce Dr. T.N. Ravishankar, who's a stalwart in the IMA circles and is very well known to everyone across the country as being a convener and has participated and involved himself in various medical legal aspects of practice with regards to the IMA, and he's been a very active participant in many forum in which he represents the IMA and the doctors in legal forum. So he's going to speak to us about the NMC and the current new features of the NMC, whether the NMC is actually pro-doctor, whether it is against us, and how we should understand the NMC and what it is trying to tell us and how we should proceed in our practices. And Dr. Sendil is going to, he's actually an NABH assessor, and he's actually a practice-oriented, quality-oriented practice person, in which he's going to deliver to us a talk on various aspects of protocols and procedures which will actually help us prevent litigations and help us to protect us from various aspects of problems which we face in our practice by following simple and basic protocols. And this is Dr. Sendil's talk subsequently. So without any more delay, I'm going to request Dr. Satyan, my convener in the Tamil Nadu Medico-legal Committee, to speak on informed consent and update. Dr. Satyan.
Sir,
Dr. Satyan
thank you,
has
sir.
been past president of the IMA Coimbatore, a very active IMA member, and of course a glaucoma specialist and a leading practitioner in Coimbatore. And we request him to speak on this particular topic.
Thank you, Murli sir. Thank you, Nirmal sir and Sujata madam, for having me here to talk on informed consent. I will be sharing the slides. Is my slide visible, sir? Hello?
Yeah, very much.
Yes, very visible, visible.
So I'm here to talk on informed consent in medical practice. So what is consent? It's an agreement or compliance or permission given voluntarily without any compulsion, and you cannot demand or compel a patient to give a consent. It is his own will and wish. So in medical practice, it refers to willingness of a person to subject himself for examination, investigation, or treatment. Sorry. So as Sujata madam said, we are no more gods. We are as the way of practice and corporatization has come into our practice. People or patient doesn't consider us God, so we are not special anymore. So you have to safeguard yourself. So history, since 1872, we had a section of Indian Contract Act, then Newburgh Act to safeguard human subjects in clinical trials, and Declaration of Helsinki was about informed consent for medical research by the World Medical Association. Even I was reading a mannitol study from Arvind Coimbatore, and they have written this as according to the Declaration of Helsinki. So it has to be declared in every ethics committee approved research projects. So coming to the type of consent, it can be implied or expressed. Expressed can be verbal or oral, written or informed, blanket or third party. So what is implied? Given automatically by the patient by virtue of his action. See, whenever he walks into a clinic as in an outpatient department, he implies that he is agreeing to be examined. So the only procedures like inspection, palpation, percussion, auscultation can be done. You cannot do any procedures. Or when he visits a lab of your center and when he rolls up his sleeve, he is implying that he is ready for withdrawal of blood or giving a blood sample. So not for any interventional procedures. So it's just a simple implied consent allows you to just examine and tell him what is the problem. You don't have any authority to treat. So the second comes the express consent. It can be verbal, as I said earlier, written or informed. Verbal, especially stated by the patient in his own language for relatively a minor procedure or therapeutic procedures in the presence of a disinterested party who is not a close associate of yourself or the patient. It can be a disinterested party like a nurse who is within your clinic. And a few examinations like rectal or vaginal examinations. In our practice, syringing or applanation, test dose or withdrawal of blood can be done. Coming to the written consent, for all major diagnostic and therapeutic procedures, it is must, both for surgery and anesthesia, and for participation in medical research, or you using that patient data for doing a medical research, you need to get an informed consent. And it has to be in a vernacular language where a patient knows only Tamil. You have to get the consent in Tamil only, or in some other language of their mother tongue. It has to be obtained from. If they don't know English and if they know their own only language of their mother tongue, then the consent should be in their language. So, doctrine of informed consent, a patient understanding of the following is must. Conditions or nature of illness, purpose or nature of procedure or treatment proposed, risk and benefits of the treatment or the procedure, risk and benefits of alternative treatment, if any, If you are planning to treat one, and if you have an alternative way of treating, then you have to explain about the risk and benefits of that alternative treatment also. The prospect of success or failure, that is prognosis, should be explained. Prognosis in the absence of intervention. If patient is not willing, not ready to give a consent, then absence of intervention, what is the prognosis? It has to be informed. Acceptance or refusal, other informed refusal, should be mentioned in the case sheet. If patient, you have informed everything and the patient is not willing to give a consent, then you have to write that patient is not willing to give a consent, and I'm not going ahead. So it has to be very. So I can quote a case regarding that. So it is like this picture. You have A, B, C, D. Then A goes here, then there. B. You have to be interconnecting everything. Therapy alternatives, benefits, harms, risk, everything you have to explain to the patient. So, in 2008, there was a thing about the Supreme Court preferring a real consent over informed consent. So, what is real consent? What is an informed consent? One of the doctrine of informed consent is according to which it is the doctor's responsibility to disclose the necessary information to the patient to secure consent. So, you have to explain everything, as I said earlier. But under the doctrine of real consent, the doctor must warn his patient of the risk inherent in the recommended treatment, and terms of giving such warning must be in accordance with the practice accepted at the time of proposal, considered proper by the responsible body of medical opinion. This is the real consent, or otherwise called Boehm's law. See, it has only 3 components. The elements of real consent, as prescribed in the present judgment, is patient gives it voluntarily without any concrete correction. Patient has the capacity or competence to give the consent. And third one is patient should have an adequate level of information about the nature of the procedure to which he is consenting. So when there is a issue of medico-legal involving a consent, usually the court examines the level of understanding of that patient to the procedure performed. So the court examines the patient's level of understanding. So level of understanding or the level of information which is delivered to the patient is very important. So what is Boehm's law? Sorry. Boehm's test was first implemented following 1957 case of Boehm versus Friend Hospital Management Committee, where he received an electroconvulsive therapy which caused him serious fractures. So when there was a litigation, the muscle relaxation has not been administered before the procedure. Boehm has not restrained during the procedure, and Boehm Boehm has not been warned of the potential risk factors. So when it came up for a litigation in the court of law, at that time, physician didn't have these things to be followed. So the physician, when they are planning to give an electroconvulsive therapy, they need not give a muscle relaxation. They need not restrain the patient, and they need not warn the patient about the potential side effects. So the case was turned towards the physician, in favor of physician. So from that point of time, Boehm test has to be incorporated in every consent. So that is considered as so what is the required protocol at that point of time, or if it is 2022 or 2023, as prescribed by the medical opinion, the responsible body of the medical opinion, it has to be followed. And it has to be exhibited in the consent form. So age for consenting, children less than 12 years, consent is invalid under section 90 of IPC. Parent, guardian, or person in whose custody is can give consent. 12 to 18 years, effective consent. As I said earlier, level of understanding or level of information given. Especially in this age group, the court will examine the level of understanding of the procedure performed with this age group, and then based on that, the penalty is levied. And more than 18 years, any person with a sound mind can give a consent. Consent in emergencies under section 92 of IPC. failure to give consent during medical emergency will not amount to battery. So you can perform a surgery or a procedure in case of medical emergency, even if you are unable to get a consent, and safeguarding patient's life is much more important than getting a consent at that point of time. Medical and not the legal consideration important life-threatening situations. Only when there is a catch, only when the procedures are absolutely necessary. So if you think that in case of emergency, only the procedures are absolutely necessary, you are allowed to do it. Do take a written opinion from an expert colleague. Signature from next of kin, if possible. Police or a hospital in charge is advisable. This is the case I was mentioning. It was a case about Dr. T.T. Thomas versus Srimati Elisa, where a patient with acute appendicitis came for treatment. Doctor examined, advised appendectomy, but patient refused to give a consent. Doctor didn't operate. Patient died subsequently. There was a case, and then this gave to the section 92 of IPC, where in case of emergency, even if you do perform a surgery without a consent, it does not amount to battery. So rules of the consent: free, voluntary, clear, intelligent, informed, and direct and personal. Ideally in his own handwriting, if something specific. Consent has to be procedure specific and person specific. As I was saying in most of the forums, if you are having a visiting surgeon or a ghost surgeon for your cataract, then the consent should mention that person or doctor's name in it, because that is the person who is performing that cataract surgery. So consent is procedure specific and person specific, and that doctor should sign in the consent form. When 2 or more procedures are performed, consent for each procedure is must. Separate consent for blood transfusion is necessary. You cannot combine it. Do not delegate the job to a junior staff or a non-clinical person. Insert an intoxicated person unable to understand the nature of consent, then consent is not necessary. So the one other thing is, as I said, every procedure has to be the consent in case of Samira Kohli and Dr. Prabha, the consent was obtained for a diagnostic procedure, but subsequently they did a hysterectomy and oophorectomy, which is not under the consent. So doctor was penalized. So when you get a consent for a diagnostic procedure, stop it there and get a different consent and proceed with a therapeutic one. So you have to get separately. So there was an introduction of blanket consent where they get a consent that I will do a diagnostic procedure, and then if necessary, I will do a therapeutic procedure also. But that blanket consent doesn't hold good in court of law. So it is not valid in the court of law. So consent of spouse is not necessary for any treatment other than performing sterilization surgery. Deals with section 92, as I said earlier, deals with case of emergency, state that any harm caused to a person in a good faith, even without a person consent, in case of emergency, is not amount to battery. Section 53 of Criminal Penal Code, an accused can be examined by the doctor by using reasonable force if requested by the police officer. So organ donation, will of the deceased is enough. Consent of the recipient is must. So which applies for a corneal transplant. So consent is invalid if it is not an informed consent obtained by misrepresentation, fraud or threat or violence, under sedation, failure to give proper information, no legal capacity to give it, a minor or insane person, given for committing a crime or a legal act such as criminal abortion, different procedure and a different physician. You get a consent for one procedure and do a different procedure. Get a consent for particularly for a physician and some other physician performing a surgery is amounting to battery. So why so important? The one core compensation in medical negligence cases are becoming a norm nowadays. Even we had a it is about a V. Krishna Kumar versus State of Tamil Nadu, which happened in 2015, where his baby was premature, discharged after a few days in neonatal therapy with 100% oxygen, but they were not informed about screening for IOP. The child became blind. So 1 crore compensation was given. So you have to be very careful, document everything, both in the case sheet and in the consent form. So 1 crore compensation is huge, huge in our practice, and it is becoming norm. We have to be very careful. So as Murli sir said, we have compiled a consent book, which is a translation of AOS English consents into Tamil. So you can, we are about to circulate and print and distribute to our practitioners and after practitioners in Tamil Nadu. So thank you very much for this opportunity.
Thank you, Dr. Satyan. And I think you have really highlighted many of the important points and absolutely must-know facts for the members regarding various aspects of consent. I think all of us as practitioners know the importance of the consent, but I think you have brought in and highlighted very important point, which I would just like to mention in brief. The consent has to be prior. That is, you have to take it well before the procedure. The consent has to be voluntary and not just taking somebody's patient's hand and putting his thumbprint on a paper and saying you've got consent. It has to be on a day and time in which the patient understands the procedure, has to be informed, and information has to be given in a language in which the patient and maybe even the attender has to understand. What are the alternatives to the procedure? Any other, like for example, if you're doing FACO, is SAC as an alternative, is ECC an alternative, and so on. Any other alternative is available. At the same time, all the consequences of not doing, as well as the consequences of performing the procedure and complications, and separate consent for anesthesia, separate consent for different procedures is extremely important. We should not assume that one single signature will authorize you to give a block, will authorize you to do a phaco surgery, will authorize you to do a vitrectomy, all with one consent. You have to get separate consent for anesthesia, separate consent from each procedure you are following. And like he mentioned in that case example, that if you're doing a diagnostic test, it does not hold good for a procedure. Suppose you're going to do a GA exam, and then you're going to proceed with the surgery. The consent has to be informed with regards to the diagnosis, the general anesthesia, as well as the procedure which you're going to take up. So make sure this is followed. I know it is superfluous to keep repeating the same thing, but most of litigations come in a court of law when the consent is improper. You have no defense. Your defense is literally nil if you don't have a proper consent, and therefore no point in saying I did the correct thing, but I was penalized. Because if you do not follow the protocol as per law, the consent is a very, very vital aspect of practice, and you will not be excused if you do not take a proper consent. We'll discuss more of this in the panel discussion. I now invite Dr. Madhavan, if he's ready. He's going to speak to us on the doctor-farmer relationship and how it goes in our day-to-day practice. Dr. Madhavan, are you ready?
Yeah. Sir. Thank you, dear President, for this wonderful initiative of medico-legal insights in the forum under the aegis of TNOA. I hope I'm audible now.
Yes, Dr. Madhavan.
Yes, sir.
Thank you. So after the illuminating talk about consent from Dr. Satyan, so something away from our surgical field, but it's a balancing act, that how to navigate the doctor-farmer relationship in these turbulent times. So a very good evening to you all, and thank you for the opportunity. So collaboration between doctors and pharma industry is for enhancing patient care. Our health care axis generally revolves around doctors, patients, and medication. And with the advent of digital technology, new avenues of more empowered patients are the order of the day.
Madhavan, could you go on screen show?
Slideshow, sir.
Slideshow, sir.
It isn't sharing, but
Yeah, we're able to see it anyway, so I think you can proceed. So if you're having difficulty in going full screen, I think it's we're able to see it anyway. Please proceed.
full screen. So, doctor and pharma industry have to join hands for research, for healthcare, for health education as well. In medicine, our primary concern is health of the patient. And in fact, we place the interest of patients much above those of physicians. And so ethics and transparency are the foundation which gives us credibility, which gives us the confidence. With these preambles in mind, we now look at what the professional ethics and professional conduct regulations had to say about our doctor-pharma relationship. So it dealt with gifts from pharma, from healthcare, hospitals. It dealt with about travel facilities for vacation and even attending for CMEs, hospitality, etc. A medical practitioner may participate in a project funded by pharma industry, provided the proposal has due permission from ethics board, from the authorities, and the funding is publicly disclosed. And we are supposed to maintain a professional autonomy, no compromise. And the freedom of medical institution is of paramount importance. We could be affiliated to a pharma as an advisory capacity, but we are not supposed to endorse any product, but we can do study and present it in publications in a scientific journal. So unlike Saurav Ganguly and Anil Kumble, we are not supposed to project in a public forum about the efficacy of any medication. Now, what are the changes in the clauses, the new NMC Act from the MCI regulation? Drastically, they have said there is no consultancy, no honorarium allowed. Earlier, court allowed doctors to act as consultants to pharma companies as an advisory capacity, as researchers, so long as the professional integrity and freedom was maintained. These conditions have been removed in the new regulation. NMC bans members from honorarium from pharma and allied sector. Only doctors who are employees of the companies can take salary and the resultant benefits. Even medical device companies, corporate hospitals, commercial healthcare establishments, or are supposed to come under the net according to our new NMC rules and regulations. So what are the penalty for the so-called alleged unethical acts has also been defined under the NMC. New rules have been made stringent and categorize freebie clause to drawing an L3 penalty, which amounts to suspension of license to practice for a maximum period of 3 months. And even the speakers and delegates, they are not spared. The new NMC rules clearly states that RMPs should not be involved in any third-party educational activity like continuing professional CPD, seminars, workshops, conferences, involved direct or indirect sponsorship from pharma companies. And so this results an annual, even our annual conference could be in jeopardy. But the Indian Medical Association has represented to the government stating that the NMC has only the medical practitioners under its review, and medical associations do not fall under the gambit of the NMC regulations. So hopefully, if such thing does come about, we could save from the double hit that the medical conferences could undergo due to the NMC regulations. As we know that the medical associations, we do depend on sponsorship from pharma companies to organize events. Now the speakers and the members themselves will think twice before getting involved in conferences, because participation in our even CMEs with educational grants from pharma companies may be a red flag according to the NMC. NMC does permit clinical drug trials, but with the condition that it should be open to scrutiny and the funding should be in public domain. So pharma and doctor relationship should be transparent. When it comes to relationship, the rule states that the RMPs should be aware of the conflict of interest situation that may arise. That is, not knowing the law is not an excuse. We are supposed to be knowing the law and adhering to the law. And what happens when the RMPs cross the deemed Lakshman Rekha, so to say? There is a procedure for filing a complaint against misconduct, and which is very simplified. The process of online complaint, filing a complaint will be made online, and both the Ethics and Medical Regulation Board and the NMC and the respective state council will have a section for the same in their website. And the complaint can be filed within 2 years from the course of action. And even the NMC under section 36 of its regulation grants itself the power to modify the guidelines. So we have guidelines for social media conduct, for CPD guidelines, for telemedicine guidelines have already been issued. So finally, it is not all. Issuing guidelines on interaction with pharma industry as and when may be required, may be amended from time to time. So finally, going through exhaustively through the do's and don'ts of this relationship, we can say doctors and pharma are part of healthcare. Both are interdependent. Ethical relations should be promoted, but should doctors be held to a different, higher standards than the rest? We have been cognizant of all the NMC regulations and implications, starting from our free medical samples that we invariably offer to our poor patients, to patient educational brochures in our OPD, our monthly CMEs, also our annual conferences will also be affected. Research work, advertisement in medical journals, there is no end to it. Doctor, patients, and drug industry, they are partners, they are friends, they are collaborators. Ultimately, it is for the benefit of the patient and the public good at large. And so, we have to be ethical, we have to be transparent, and hope that NMC relaxes its guidelines for the benefit of our association and as doctors, and also which will be for the benefit of the patient as well. Thank you. Thank you for your patient hearing.
Thank you, Dr. Madhavan. I think you literally hit the nail on its head, and brought in the correct perspective as far as our practice is concerned and our relationship with the pharma and about our CME programs and our conferences and so on. I think it's a very complex relationship which we now currently have with regards to accepting even a freebie from the patient, from the pharma companies. Some of the representatives come in and give you a small gift, which according to the older ethical regulations, up to gifts say up to 1,000 rupees in cash or kind mostly, some kind of a compliment, a pen stand or a pen or some kind of a thing which you keep in your practices. All those things are now frowned upon. Any kind of a gift or a compliment or any kind of souvenir should not be accepted, which is what we seem to be heading towards. And any kind of even sample medication which the company is actually handing over to us in terms of pharma samples. Even samples, the company has to actually pay GST when they give it to us as samples. And I believe in the future it could come that the samples which we receive will be taken as a gift to the doctor, and we may have to pay TDS for the gift which are being given as samples. So make sure that you don't accept samples so easily and don't take big boxes and cartons of samples thinking that you're doing good for the patient. And the patient, of course, is in the top of our mind, but be safe yourself and don't accept gifts and compliments for which you may have to pay tax and TDS and so on. It is going to come, and we have to be careful about that. And for the foremost thing, understanding the doctor-farmer relationship, I think Dr. Madhavan has elegantly pointed out that we have to maintain our integrity. Do not let down our integrity. Do not let down our ability and autonomy to practice what you think is fair and good for the patient. The patient is the first and foremost priority for us. Do not compromise by writing a drug or supporting a pharma company because they have done something for you. So keep that relationship clear. They may pay for you in a conference, they may sponsor a session, but that does not mean that you have to write a product for them. There is no obligation on your side to write or endorse any product either in a conference or in a public or any kind of a social media, because you're casually mentioned in one of your YouTube channels that you continuously write one particular drug for some particular disease. You may be quoted, and that is actually becomes illegal. You cannot supposed to endorse any product or any kind of method or device, or even any particular brand of IOL and so on. All of those things are going to become serious. Do not endorse any product. Keep your integrity well above all of these things, because we're now heading towards more and more of what we call as practice litigations, and people are questioning whatever we do. And we have actually come down in the eyes of the public as being a not so noble profession. So to get us back into the so-called noble profession, let us keep our integrity high and let us maintain a good and safe doctor-farmer relationship by not accepting gifts, by not endorsing products, by keeping our integrity far above everything else. And this sponsorship of conferences, taking us out to say vacations. That is how actually the Modi government has actually picked up various amounts of frauds and things in which doctors have been taken and the families have been taken for vacations in various states like Gujarat and Maharashtra. This has come under the scanner. That is the reason why the government is coming down heavily on doctor-farmer relationships, noticing that these people are sponsoring vacations and personal trips and so on. I think all this from our side, we have to voluntarily stop accepting and doing all this. I think Dr. Ravi Shankar is unable to join us immediately because he's having some internet issues with his phone. So he said he will join us maybe in after about 15-20 minutes. So I now therefore request Dr. Sendil to speak to us on a very important aspect of practice. He's actually an NABH assessor and a leading practitioner in GR. He's going to talk to us about how to use protocols and standards in preventing litigation in our practices. Dr. Sendil. Yeah, welcome, Dr. Sendil.
You are muted, sir. Yes, sir.
somebody who has regards to his practice, and a legal notice or someone is received. And he has actually been active in responding to such notices. I think we all have to understand that aspect of our practice, that we all face the threat of litigation and legal notices. Anytime we feel that someone sends us a letter, a legal notice from a lawyer, or even a question from somebody as a patient, we should not immediately respond by instant. We don't have to respond on the minute or in the same day. We think it out, draft a response, take advice from a legal practitioner, take advice from the IMA, take advice from our TNOA medico-legal cell, and then sort of respond within a week or a fortnight. You don't really have to instantly respond to a notice, besides following safe protocols to prevent litigation in practice. Dr. Senthil, you can share your screen now. Yeah. You're still muted, I think.
Yes, sir. I'm sharing my screen, sir. 1 second.
Dr. Nirmal, would you like to share any insight with regards to what has been spoken in the last few talks while Senthil starts off?
Yes, Murli, I think two important topics, the consent and the pharma arrangement. I thought we'll take the questions during the panel discussions. So if Senthil is ready, we'll start.
Proceed.
So
I think all of us are having internet issues. I am also having internet issues for some reason. Seems to go on and off, and Dr. Ravi Shankar is also not able to join immediately. We said he will come in a few minutes later.
Okay. Senthil, if you are ready.
Yes, sir, but screen is not being shared, sir. 1 second, sir.
Okay, so you've given the share screen option. Are you able to
Yes,
see
sir.
that? Okay. So it's your presentation in the desktop. In that case, you can.
Yes, sir, it's in the desktop, sir. 1 second.
Okay. 1 second.
Lisa, shall we start your talk at least?
Senthil?
He has a problem.
Yeah. Senthil, are you ready?
Yes. I think Sarah has left an exam.
Logged out?
Yeah, logged out.
Okay, Senthil will log out and then rejoin. We have some connectivity issues.
So I'll start sharing my screen so that I can get ready with my talk. Yeah.
Okay.
So, few words about Dr. Murli sir. He is going to talk about clear vision on generics. So he is a director of Swami Eye Hospital and HOD of SMF Chennai, a renowned glaucoma specialist, chairman of Medico-legal committee of TNOA. Then he himself is a law graduate. He completed his PG diploma in medical law and ethics from the National Law School of Bangalore. So he knows in and out about what is ethics, what is within the bounds of law, and what is against or out of bounds in the case of medical legal issues. So Murli sir will be clearing our doubts about generics and recent NMC guidelines about prescribing generic medications instead of medications from MNCs. So Murli sir, it's your time.
Thank you, Satyan. I think I'm audible and screen is up.
Yes.
Screen is up. My slides are seen. Yeah.
Loud and
Thank
clear.
you. And So actually, the NMC actually stirred up a hornet's nest by starting off on a new rule and regulation which say that all our registered medical practitioners should start prescribing only generics and do not write a brand name and so on. This actually created a storm. All of us could not understand what is the actual difference between the branded and generic, what is the law and how should we proceed further, how do patients get generics and so on. So I'm going to give you a little perspective on what is the difference between branded and generic medication and what is the law regarding them. So I think for some of us who understand what is a generic drug, it actually means that a pharmaceutical drug that contains the same chemical substance as the drug which has been produced and protected by a chemical patent. So a generic is the same quality and performance as the brand which originally came in. So the generic is actually the same chemical substance as a brand which was originally innovated by somebody who is a pharma company with R&D has brought in the brand. So generic is only the same chemical name, same quality, same performance. But why do we want generics in our practice? This actually is our publication in 2017, which we published and looked at various glaucoma medication which was available at that time. We looked at a generic brand and compared it to the actual innovator brand. We find that there's a huge difference in cost, maybe even 30 to 50% less than a branded medication, the lower cost per bottle. And therefore, this would translate to a lesser out-of-pocket expenditure. This is a very common word which is used in health laws and ethical practices and the regulations, saying that the patient spends out of his pocket. The government is not able to meet the expenditure. So his out-of-pocket expenditure increases when he's using costly medication. So when we support a pharma company and write their branded drug, the pharma company benefits, the patient actually spends out of his pocket. So the decreasing out-of-pocket expenditure seems to be better off if you are going in for a generic. And of course, when the cost reduces, possibly the patient is likely to be better adherent and use drugs which he can afford. So therefore, maybe result in a better adherence and so on is our understanding. So when can a generic become available? For example, if you look at glaucoma medication, if you look at the patent expiration date of the drug, let us say Xalatan or Lumigan or Restasis or various other drugs which are originally brought in by an innovator company, the patent expires after a particular duration of time. So once the patent expiration is over, then other companies can start making the same drug, for example, Bimetoprost or Travoprost or Cyclosporin. Once the patent expiry has occurred, then a generic can become available. Until the patent expiration date is over, a generic cannot be brought into the market. So the US FDA criteria for a generic is that the generic should have the same active ingredient as the brand name product, should also be identical in strength, dosage, form, and route of administration. It should not, if they do not contain the same active ingredient, then a clinical bioequivalence study must be performed for any systemic medication. Then the blood level also should be measured if it's a systemic drug. The generic must also be manufactured using the same standards and the good good manufacture practice guidelines which are available for practice manufacturing these drugs are required for the brand name products. The same GMPs have to be complied with. The same requirements that the FDA has for a brand name drug from batch to batch, strength, purity, and quality must be met by the generic. These are stringent criteria, but many companies do not actually follow this by the book. The problems with generic, what are the problems with generic ophthalmic medication is that it is not practical for us to measure bioequivalence or ophthalmic medication. And the FDA also does not require a clinical trial demonstrating that the generic is as effective as a brand name medication in patients. The inactive ingredients can actually differ. You can have a different preservative, you can have a different buffer, you can have different antioxidant, you can have thickening agents, you can have different volumes and so on. The bottle characteristics vary. The shape, the color, the nozzle, the dropper, the drop size, the squeezability, the various aspects of the drug and its physical characteristics can actually vary. That is a big problem which we face in our practice. And in India, we should understand that we don't really have too many of these true generics, are not freely available. For example, if you have Latanoprost, which is branded as Xalatan by Pfizer, earlier it was Pharmacia, and the generic should actually be Latanoprost. And the company that makes it is actually in the right at the bottom of the box. The main drug as the chemical name should be known as Latanoprost. So this is how a generic should be available. they are not freely available. Suppose if I write latanoprost, the patient can go hunting around local pharmacies and various outlets in his area and may not find it, because the latanoprost is actually a brand name which you have written earlier. So the generics are not freely available in India. And we have what we call as generic brands. For example, if Lumigan is the innovator brand, Careprost made by Sun Pharma or Bimetaprost made by Sun Pharma, which actually is a name coined by Sun Pharma, is available as a generic brand. Similarly, if Ganfort is the brand of Bimetaprost with Timolol, which is the original one, we have Careprost Plus. So this is a generic brand. Generic brands are what we all used to writing. Generic brands are available in most of the pharmacies because they are made by pharma companies as generic brands. In the Indian context, generics, as per the National Sample Survey of Healthcare Medication, this is actually a very important principal component of total health expense. 72% in the rural areas and 68% in the urban areas. The low-cost brands may actually help lower the health expense, because the health expense is very high and out-of-pocket expenditure. So the generics only policy actually makes economic sense, because it safeguards the health of the generic drug manufacturing industry. And India can claim to be one of the largest suppliers of low-cost medicines in the world. If you look at Cipla, Ranbaxy, Sun Pharma, Warren, Oralab, so many of our ophthalmic companies are also the world market leaders. And India has a huge market share in the global generics market. So it is good for India to manufacture generics. It's good for India to take it across the world, export it. But you must understand that the WHO good manufacture practice guidelines have to be stringently followed, and the FDA approved manufacture facility has to be there. So this is the other side of the coin, in which generics are preferred. You have low cost drugs. You have Indian manufacturers making generics and selling across North America, across Europe, across Africa and other parts of Asia and all that. But the law about generics in India is that the Indian government actually encourages more drug manufacturing by Indian companies under the Patent Act. The Patents Act actually removes the composition patent for food and drugs and keeps the process patent shortened to a period of 5 to 7 years. So most of the Indian companies actually reverse engineer the new process for manufacturing low-cost drugs. And the Code of Ethics also, which has been enforced till now, the 2002 Code of Ethics, asks us to prescribe generics by name only, because purely for the reason that we want to cut the doctor-pharma nexus, reduce cost for the patient, and so on. The newer NMC regulations is awaited on the prescription of generics by RMPs. It just came in and then it was again rolled back. So what the new NMC guidelines said was that a registered medical practitioner, RMP, should write only generics. For example, with combinations, it becomes a challenge. Suppose you have more than one drug for say any multivitamin or some other tablet or something other than ophthalmology, you will find it's a very complex thing writing all the drugs, and dosages and prescriptions are very complicated writing generics. So, and the availability is going to be an issue. So the lower awareness and corruption have given rise to a nexus between doctors, chemists, and farmers. That is the allegation now. And the pressure from international pharma companies, the recent UN report, which has given precedence to human rights over patent rights, it supports India's move for affordable generics. For example, the role of Cipla in AIDS medication in Africa, I think all of us are aware that because of Cipla's role in reducing the cost of medication in generic form for AIDS, it has actually revolutionized the way AIDS is being treated in Africa. Some of you may have seen the film of Cipla on how AIDS medication, their AIDS medication is actually helping patients in Africa who can't afford costly branded medication from the US. And same thing, I think we all aware of the COVID vaccine patent waivers during the COVID time, in which India is able to manufacture vaccines with patent waiver from other companies in the US. The Jan Aushadhi, or the generics pharmacy, is a very good program launched by the central government. Affordable medication for all. But you will know that, for example, in your own areas, have you all seen any Jan Aushadhi pharmacies in your area? You will find that maybe there are about a handful of Jan Aushadhi pharmacies. Let us say in Chennai, you may have 20 or 30. How about the lakhs and lakhs of population, and the number of pharmacies are obviously inadequate to cover the population need? What about the rural areas? And what about the choice of the drug? If you write as a latanoprost, if you write amoxicillin, the choice of the drug is actually left to the pharmacist to write the generics. And what about the efficacy? Do we know about the efficacy of every generic which is available in the market? Has it been checked? Has the safety been checked? So it may lead to unscrupulous practice, and not all available drugs are present in these kind of generics only pharmacy. So, but the generic pharmacy is probably the future. You will see a list of drugs. You will find what is available in a generic pharmacy like the Jan Aushadhi pharmacy. You will find that the drug is about 1/5 to 1/10 of the cost of the branded drug. So there's no doubt that the price advantage is there. If this concept of generic drugs gets across and all pharmacies start keeping quality generics, then maybe it's a way forward for reducing healthcare costs and so on. But we are far from the reality. The reality is far from what we will have in mind. And some of the problems with generics, the published literature, if you look at one single study which was published, from Shankar Nethralaya, this actually looked at a crossover study of patients with glaucoma, whom we have they compared Xalatan with a generic product generic brand made by Sun Pharma. To look at if the drug was taken off, the efficacy dropped. If the drug was reintroduced, the drug actually started working better. And this has been our practice and our experience with various kinds of generic ophthalmic brands. And I'm not taking any example of any particular brand, but we noticed this with various generic brands as compared to the so-called innovator brand and so on. This is a study again looking at some of the generic products which are sold by Indian manufacturers in the US, in North America. Malik Kahook looked at the study comparing active ingredients in a brand versus generic glaucoma medication. The mean concentration of the active drug was unchanged by increasing temperature and also significantly reduced in the generic versions. This was clearly pointed out in the study. And he also found a high level of particulate matter, high level of impurities in generic bottles. All of them are generics sold in the North American area and made from Indian manufacturers. So this is the study which was published, which clearly shows huge particulate matter in the bottles and quality issues with regards to various brands of drugs which were manufactured as generics from Indian companies. We did a study some time ago called as a Chennai glaucoma drop study, and we did find that the lower cost per bottle of generic brands, but the annual cost, of course, is higher if you're going to use a cheaper drug. The variable drop size, the acidic pH in some of the brands, the problems with squeeze of the bottle. Different bottles have different squeezing rates. The patient tilts it and squeezes it, put in multiple drops. So these are all the issues with the generics and generic brands. This is an example of one of the drugs which was used from a generic brand and resulted in a corneal ulceration after repeated attempts to switch. Then the patient actually recovered. This is possibly attributed to the surfactant, the stearic acid polyester, which is the inactive ingredient in the drug. I think you all must have come across this recent press report of Indian-made lubricants, which came from our own Chennai. The artificial tears, which was manufactured by India's Global Pharma Healthcare Limited, which is actually located somewhere in Chennai. It is not sold in India in our practice, but sold as generic to the US. And it resulted in Pseudomonas infection, corneal ulcers, and some of them developed Pseudomonas-related systemic infection like pneumonia, resulted in death also. So this is the state of generic medications which are available from our sources in India. So what about, this is an editorial, review article which I had written in the Tamil Nadu Journal a few years ago. And this makes very interesting reading even now. You can probably look up and look at why generics are less expensive, what are the various aspects of the law as far as generics are concerned. So to summarize, generic brands have a distinct cost advantage. They're going to be here to stay, as Indian government is very keen on generic usage. You cannot get away from that fact. The very serious concerns with regards to efficacy, quality, stability, and toxicity of the drugs. So therefore, as a caution, I would advise before starting or switching to a generic brand or generic drug, closely monitor the patient and counsel the patient that you are actually using a drug which is not the innovative drug. The patient has the right to know, even though the cost is less, has the right to know that you're switching to some other generic brand and whether the same efficacy is going to be there. So this you have to keep in mind before you start off any patient. And of course, I would like to leave you with the impression of understanding what this actually means. On the slide you are now seeing, I recently saw this in one of our doctor's letter pads and a file which the patient is carrying. So the MCI as well as now the new NMC, the ethical regulations, states that your degrees and qualifications must be according to what is listed by the National Medical Commission. You cannot sort of add in, let us say, alphabets behind your name, and which says and claims that you are specialists in various other aspects of practice and so on, without being actually qualified. That is one aspect of practice. So please put in only degrees and qualifications which are National Medical Commission recognized. Do not put in fellowships and alphabets and other qualifications, which you may be a specialist, but do not use what is not allowed by the NMC. Your letter pads and patients should not be taken. Understand that you're a specialist unless you have a qualification. The other aspect of what I would like to highlight is these kind of illegible prescriptions. So this we see very commonly among our colleagues and among our ophthalmic practices. So kindly avoid illegible prescriptions. Kindly avoid notes which are not legible. And these are going to create a lot of trouble for you if it goes to a litigation, if in a court of law. People are very sarcastic and ask you to read out what is written in a prescription like this or in a medical note like this. Kindly write legibly, write in capital letters if your handwriting is not clear. And of course, if you're using an EMR, EHR, make sure you spend a little time in putting in the data, and whatever data you put in cannot be edited later. To make sure that the legibility of all our prescriptions is there in our practices. So with that, I will stop sharing and request our next speaker. Is Dr. Ravishankar available online?
He has joined.
Would you like to speak, sir?
Are you able to hear me? Are you able to hear me, sir?
Yes.
Oh, yes, sir. Very much, sir. Would you like to speak now, sir?
Yeah, I'm ready. I'm ready. Give me the sheet screen.
Yeah, please share and start speaking, sir.
Are you able to see my screen, sir?
Yes, sir.
Yes, sir.
You can make it slideshow.
Yes. Is it okay?
Yes.
Yes, sir.
I think thanks TNOA, thanks Dr. Murli, Dr. Nirmal Frederick, and every one of you for giving me this opportunity to talk something about our NMC. Anybody who gives a rule for us are bad people. That's a common citizen's perception. But let us see what is the character of a professional as described by Jackson and Powell. The nature of work which is skilled and specialized, and a substantial part is mental rather than manual. Committed to moral principles which goes beyond the general duty of honesty and a wider duty to community which may transcend the duty to a particular client or patient. Professional associations will regulate admission and seek to uphold the standard of the profession through professional codes on matters of conduct and ethics. This is what a professional does an introspection of how he performs for the society, for the knowledge he has gained, and there are only 6 professionals in the world, and we are considered to be higher in the status, in the higher status in the society. But let us see what is NMC and what they do. NMC was got a mutation from Medical Council of India. When they wanted to change the Medical Council of India to NMC, they had a lot of problem, but then the government was strong enough to convert them into the NMC. The main issue had been different, but what they wanted was to improve access to quality and affordable medical education. They want a high quality medical professionals in the entire country. They promote equitable and universal healthcare that encourages community health perspective and makes service of medical profession accessible to all the citizens. Encourage medical professionals to adopt latest medical research in their work and to contribute to the research. Objectively assess medical institutions periodically in a transparent manner. The word transparent manner has to be taken here into account. That was the reason why they transformed the MCI to NMC. Maintain a medical register for India and enforce high ethical standards in all aspects of medical service, and have an effective grievance redressal mechanism. transparent manner and grievous mechanism. Let us see over the time in our slides. And now, what is the constitution for the National Medical Commission? Its precedence has been the Medical Council of India. I have taken this from Wikipedia. The chairperson is Dr. Suresh Chandra Sharma from the Ministry of Health and Family Welfare. The commission shall consist of the following persons to be appointed by the central government. Take it again, appointed by the central government. It is not an elected body, a chairperson, 10 ex officio members, 22 part-time members, vice chancellor from 31 state universities, and members from the State Medical Council, which numbers to 29. And these are the members who are elected. Rest of them are all nominated members from the Government of India, Ministry of Health and Family Welfare. And the vice chancellors, you know, are all nominated by the respective states. And only the members of the State Medical Council are people who are elected. They have 4 people from the IIT and IIM. People might think, why from IIT and IIM? Because of their efficiency in managing the IIT with this of an international standard, and management also has to be that part of the management of the Medical Council. People from the AIMS, Director General of Health Service, National Accreditation, and UGC are there. 50% of the seats are being controlled by the fee structure that is being guidelined by the National Medical Commission. And you know, this has been of strict force in the last 4 years. And then this is again on the NMC's principle. Let's see what the National Medical Commission has envisaged to grant license to practice medicine at mid-level for a community health provider. And who are these community health provider and where do they get the knowledge of modern scientific method is not being given in the National Medical Commission. They talk of community health provider to grant license under subsection may practice medicine to such extent in such circumstances and for such period as may be specified by the regulation. It's been 3 years and this has not been defined. Suddenly one day one state might enact an act trying to make quackery authenticated with this law from the National Medical Commission. And today in this country, quackery is abundant. When we have 10 lakh of qualified practitioners, we have equal number or more number of quackery in this country. And they always say, we don't go to the rural. And I don't think that statement holds good in the last 2 decades. People have gone to the periphery, people are working in the periphery, and the health system has gone to the periphery to a great extent. And what is the need for community health provider? And what is the authenticity of the National Medical Commission, who are supposed to guide qualified persons, who are supposed to monitor the medical colleges that produce MBBS graduates? And this is a big flaw in the National Medical Commission, and then consider whether it is friendly or foe. There are powers of the National Medical Commission to call for a doctor and question when there is a complaint against him. No person other than a person who's enrolled in the state register or the national register, or as the case may be allowed to practice medicine as a qualified medical practitioner. Any person who contravenes any provision of this section shall be punished with imprisonment for a term which may extend to 1 year, or it may fine which extend to 5 lakh rupees or both. 3 years, I don't think any single person has been taken to task for having prescribed modern medicine in this country by the NMC. This is where they have powers to call on us to summon and enforce the attendance on any defense or witness and examine the witness on oath. They can call a medical practitioner registered under the State Medical Commission and ask them to say oath, and then ask them to give evidence for the treatment that they have rendered. The documents, they call for documents, they can call for affidavits, and they can call for witnesses, and they can give penalty from level 2 to level 5 in consultation with the State Medical Commission And this need to be publicized widely on the website and other platform as they deem fit and communicate to the employer, the hospital, the healthcare institution of the RMP, and respective medical association, societies or bodies. They have the right to call for a doctor who does a negligence or a problem when they receive a complaint. They have also the right to call for the quackery and then put them for task. But have they ever done it? This is the big National Medical Commission that has taken into action to try to educate the younger graduates. That's all fine. I think generic medicine was talked by Dr. Murali. Prescriptions also was by them. The code of ethics is there, running to 54 pages with 6 chapters and with 10 guidelines. In fact, the penalties have been given so well in the National Medical Commission's guideline. Consent also has, for the first time, considering to the MCI's guidelines, there were no guidelines there. Here there are 10 guidelines, and they have given a guideline on consent also, which is so perfect for us, because of late, you would also know that the National Medical Commission has given us a form of the court judgments and their comments also. How you behave in the social media, guidelines have been given, certificates have already been there, record maintenance is there, and record maintenance, what NMC says might be authenticated, because every state has got a different Clinical Establishment Act, and the minimum records maintenance for them vary from state to state. 8 years in our state, 3 years in certain states, 10 years in certain states, but the National Medical Commission gives for 3 years. Certificates and reports for several acts, PCI, PCP, MDT, transfer, human transplant, organ act, all these things are there. Very well given guidelines in the National Medical Commission's Ethic and Medical Registrations Board's notification, and how you should conduct continuous professional development also has been given. The entire 10 guidelines is all so perfect that if we follow it, I don't think legal issues or ethical issues will be there for any person. But then come back here. Professional conduct review, the case archives have been given of late. And suddenly the National Medical Commission has become media oriented. Now they are releasing lots of things into the media, probably to educate the public, to take the medical profession to task, or to try to be very strict and vigilant against the medical profession. That's all fine. If we follow ethics, there is no issue. Of late, something about the signboard was given, and you think Tamil vernacular carried it on the first page. They are talking about research. No guidelines or no committee has been formed. 3 years have been there, and nothing has been done on the research. And how are we to go? We still depend on the ICMR for it. And if NMC has want to become powerful and want to guide us on that, even after 3 years, they have not done anything on the research. That's my perception. That's how I got the information from their website. Telemedicine, running to 48 pages. In 2020, they said they're going to course on the telemedicine platform. Telemedicine is not at all an alternative for the patients to come and reach you in person. Telemedicine and telehealth, 2 different things should be defined by the NMC, and telemedicine is not a one which is acceptable. And even after 3 years, when they have not come down with a certified course, I don't think they are going to come in the next 10 years. Right? They are trying to restrict hospitals with the RMPs who are registered with the hospitals, but then hospital is a different industry. Medical profession is a different profession. Profession and industry are linked in the healthcare services. And economics is another big issue on the hospitals. And if you are trying to restrict the hospitals on advertisements on certain other things, within the ethical framework, I think NMC has no power to restrict the healthcare industry. Maybe they can restrict the professionals, but not the healthcare industry. Healthcare industry is in total perception, in a total value, and working on the healthcare industry, I think everybody will find it difficult for it. And then finally, let me finish it quickly down. And NMC is a friendly foe. There are things, it's in the early stage. But what was the reason NMC was transformed from MCI was certain things the government wanted and the people wanted to change in the medical profession. And if they want to change the medical profession, I think put your hand on the shoulders, don't take the gun and shoot us. And if you try to give the law accordingly and in time, the friendly foe will be a friendly person. Thank you, Dr. Nirmal, Dr. Murali, and TNOA for giving me this opportunity. I hope I have stuck with the time. Thank you.
Thank you, sir. Thank you very much. And I think it's a very nice talk. And I think you highlighted most of the important aspects of the NMC and our understanding. And any comments, Satyan?
Nothing, sir. Sir has said everything very precisely. And I think when it comes, probably it might be few edited ones. Probably we have to, before that comes out, we have to be in full force to make it slightly
we
lenient on our
have
side.
seen a trailer of what is to come. So I think
Yes.
we have to definitely be prepared for the big movie when it comes. So
Yes.
be prepared that the watered down version may be coming. What do you say, Dr. Vishankar?
Our defect is we don't take the initiative, let the person do it, and then finally they keep shouting from our side.
Yes, sir. Yes, sir.
We should take the initiative and we should tell them, so that tomorrow when they are trying to review what they have received, we should have given the information on telemedicine, telehealth, the rules, regulation for all these things. We should take the initiative, and that should be the responsibility of all the associations, including IMA.
Yes, sir. We need not.
I request you to stay back for the panel discussion, sir. So we have one more talk in between. Dr. Senthil is going to talk to us. And after about 10 minutes, I think we're going to have a brief panel discussion. I'd like you to stay back for that, sir. Dr. Senthil?
Sir, you are muted, sir.
Is my screen visible, sir?
Yes, sir.
Yes, sir. It is visible.
Is it visible now, sir?
Yeah,
Yes,
make it play. Yeah, click that play. Yes.
Yes, sir.
So protocol as guardians, so safeguard against litigation. So when we tell as guardians, that should be something like an enemy, foe, or opponent, or like Sar said, a friendly foe. So that should be our patients. So before getting into the topic, I would like to thank our TNOA President Nirmal Frederick sir, Murali Harigra sir, Satyan sir for the opportunity given to me. So negligence by a professional. So 1 second. A professional may be held liable for negligence on one of the two findings. So either he or she has not possessed the requisite skill which they have professed to have possessed, or he or she did not exercise with reasonable competence in the given case the skill which they did possess. Ordinary competent person exercising ordinary skill in their profession. So we already know what is medical negligence. The negligence is the breach of a duty caused by the omission to do something a reasonable man, guided both by those considerations which ordinarily regulate the conduct of human affairs, would or doing something which a prudent and reasonable man would not do. So essential components of negligence are duty, breach, and resulting damage. So we are going to look into that to avoid litigations. Okay. So though considered as a noble profession and practicing with good knowledge, required skill and expertise, medico-legal issues arises with improper communication, cost-related issues, and outcome of the treatment. So of course, outcome of the treatment is not in our hands. And this content is going to be a summary of exactly what was talked in the past 1.5 hours. So communication, it includes the scope of services provided by the organization and display of the degree and expertise of the treating doctor as per NMC guidelines, and do's and don'ts for the patient to be displayed in the hospital, and the discharge summary related to the treatment, proper consent and mechanism for receiving a complaint. So first let us see the duty. Duty is, as soon as we accept a patient for treatment, the duty starts. So it should be as per the treatment accepted, should be as per the scope of services defined by the organization. And for the given scope of service, physical infrastructure and equipment and manpower should be adequate to provide for the defined scope of services. So the changes, what we are supposed to do are not advanced changes from what we are doing now, some basic or elementary changes to get rid of medico-legal problems. So coming to the breach of duty, to avoid breach of duty in patient care, it should be uniform, especially in an ophthalmic setup where there are a lot of camp settings and pre-cases operated. A care plan should be after a proper examination that includes a general examination, including vitals, basic systemic examination, local examination, including vision, slit lamp, duct, EVO, extraocular movements, intraocular pressure, and fundus, including peripheral retinal examination. We all will be aware that one of the earliest medico-legal cases started with the doctor not doing an intraocular pressure examination with the shears, and the patient having an glaucoma and went on to lose the sight. And in the early lower courts, the verdict was in favor of the doctor, and in the higher court, it went against the doctor for not doing a shears examination and reassessment at regular intervals. So before discharge, examination by staff nurse for vitals is a must, and examination by surgeon or anesthetist before discharge is a necessity. So even though it seems simple, if we go into a medical audit of the case sheet, so definitely we'll be surprised to see that we wouldn't have documented in some of the cases, definitely we wouldn't have documented examination by the surgeon after the procedure. And counseling the patient for post-op care and review, it's a must. And medical record should provide complete, up-to-date and chronological account of patient care. Procedure for retaining a patient's clinical record, data and information should be in consonance with the local and national laws and regulations, like our Ravi Shankar sir told in his presentation. Provision for emergency care or preparedness. Even though we can see or we may not see once in our lifetime, we have to be prepared for emergency care, cardiopulmonary resuscitation, availability of oxygen cylinders is a must, ambulance availability, access for critical care in the hospital, and availability of blood and blood products, either that can be in the hospital or an MOU can be obtained with the nearest center. Safety measures for vulnerable patients. For that, first we have to identify who are the vulnerable patients who are going to come into the hospital, and our staff should be aware of them, and then safety measure has to be taken care of. Availability of firefighting equipment and security arrangement like CCTV in all acceptable areas. Consent that has been dealt in detail by Dr. Satyan sir, and I will just go through in brief. A doctor who treats without valid consent will be liable under tort and criminal laws. And Sarah has told in detail about implied consent and the informed consent. So consent is not required in medical emergencies. It is implied, and in treatment of notifiable diseases, medical examination under Section 53 CRPC, examination of a patient at the request of police, or by the court, psychiatric examination or treatment by court order. As far as possible, consent must be obtained from the patient when he or she is competent to give it. Consent should be obtained by the medical officer who is treating or operating the patient in a language and form that the patient can understand. Anesthetist or the team member should obtain anesthesia consent. For separate procedures, separate consent is required, and consent should contain about the details of the procedure, alternatives, advantages and disadvantages of available treatment, possible complications, details regarding reusable items like our fake coat tip, sleeves, and all the things, and details regarding multi-dose vials, if any, used if any, and need for resurgery, possible complications should also be explained in detail. So factors in informed consent, there should be a disclosure of information. Free and voluntary decision making by the patient is a necessity. Patient is legally competent to decide. And patients are educated to make informed decisions pertaining to plan of care, preventive aspect, possible complications, expected results, and cost at the time of admission. So most of the time, a patient who had some inconvenience or who is about to give a complaint would first give that complaint in the organization itself. So there should be a mechanism for receiving a complaint in the organization, and that should be visible in the prominent area, either in the form of complaint box or feedback form. And there should be a mechanism for complaint redressal. And following a complaint received, there should be a corrective action and preventive action after studying the complaint in detail. And as far as possible, it should be communicated back to the patient about the complaint raised by him and the necessary changes which were made regarding that complaint. Next part is the discharge summary. It should be given to all patients leaving the organization, and it should contain patient name, UHID, date of admission, surgery, discharge date, etc. Reason for admission, significant findings, diagnosis, and patient's condition at the time of discharge. It should contain investigation results, medication administered during the hospitalization, and should not contain medical abbreviations. Date of review should be mentioned, and along with that, conditions for emergency consultation and contact numbers should be given in that. Coming to the prescription or medication given, the prescription should be in capitals, like Murali Harigrasha showed. We are seeing many prescriptions which are not legible, and prescription should be properly signed, dated, and timed with seal. No abbreviation as far as possible should be in that prescription, and follow-up date should be mentioned in it. So before dispensing an medication, expiry date has to be checked and identify the patient before administration of a drug. Use of multi-dose vials, consumables, implants should be as per best practices in national or as per international guidelines. This is the prescription format given by Tamil Nadu Medical Council. So the prescription should contain the doctor name, his qualification, full name, contact name, mail, phone number, mail ID, etc. Name of the patient, address, age, sex, weight of the patient. Name of the medicine should be written along with the dose, and when it is administered or to be given, morning, afternoon, night, and the total days of the given medicine to be given. Below that, the signature and stamp of the treating doctor should be available, and the bottom of the prescription, it should be dispensed by the pharmacist's name and the signature name of the pharmacy. So prescription could additionally contain 1 or 2 lines for usage of medication, how to use wherever necessary, and patient should be educated about safe and effective use of medication, and educate patient about the potential side effect of a medication. For example, a patient with steroid, we should mention that it should be only be taken as prescribed. And for drugs like glaucoma, need for continuous treatment till the doctor says or until the patient goes for surgery. These things should be documented. And one important aspect to prevent medico-legal problems or litigations is doing a quality improvement program or audit in the institution. That is a means of continuous monitoring, and that has to be done at regular intervals. Audit has to be done in the case sheet audit, hand washing, adherence to protocols, patient safety, medication management, sentinel event, waiting time in the hospital, etc. Or as per the complaints received. Additionally, in some areas, as per the complaints received from the patient. Based on that, we have to give periodic training to the all staffs, and corrective and preventive actions has to be taken. And awareness of medico-legal cases. Any medico-legal case is any case of injury or ailment where the attending doctor, after history taking and clinical examination, considers that investigation by law enforcement agencies are warranted to ascertain circumstances and fix responsibility regarding the said injury or ailment according to the law. So once there is an awareness, we will do what has to be done, and intimation to the police has to be given, and relevant data has to be kept in the hospital. And this data document has to be kept till it is heard in the Supreme Court or final court of law. The awareness of this laws like Clinical Establishment Act, Consumer Protection Act, Biomedical Waste Management and Handling Rules, Transplantation of Human Organs, Drugs and Cosmetics Act, Narcotics Act, Right to Information Act, MTP Act, PCPNDT Act, and various certifications, Pollution Control Board, Fire Safety Measures, Building Stability Certificate, Labor Act, ESI, Lift License, Genset License, and adhering to that is important in preventing litigation. So let us remember, running speed of a car is determined not only by the accelerator, also because of availability of proper and effective brakes. So protocols and licenses are like powerful brakes meant to protect us in practice. Thank you.
Thank you, Senthil. I think your brake analogy is fantastic. So I think we all should know where to apply the brake and not to keep accelerating in our practice. I think our natural tendency has to be into, once you become proficient in your work and you're excellent and excel in your practices, you keep on accelerating without knowing where to brake. So we should know that. And I think very important take-home messages from your talk, I can straight away say, is that we must have a mechanism understanding the NABH protocols and quality and other things, is to have a feedback complaint mechanism in which you can straight away prevent litigations, because somebody has something against you, you should be willing to respond and listen to that. So I invite suggestions, invite comments, and invite even a complaint. And straight away at that stage, you can actually sort of mitigate various aspects of snowballing into a larger controversy and so on. So have a feedback mechanism, have a complaint box, and respond to that in a reasonable time frame and so on. And I think you also did mention about the medico-legal register. I think many of us fail to maintain a medico-legal register. We take it very lightly. Even eyelid trauma, corneal lacerations, industry-related work, foreign bodies which come in from an industry. We've had patients coming back after several years saying, I had a foreign body. This was during my work in an industry, and I have a corneal opacity in the center which obstructs my vision. I have 30% vision disability, and I'm going to file litigation against a company because it's a work-related injury. If you do not have any record of maintenance of the foreign body, how much was the opacity, what is the vision recorded, and so on, you may have a lot of difficulty in explaining to a court of law. So maintain records, and all medico-legal trauma, anything which you seem suspicious, make sure you maintain it in the medico-legal register. I think many of us don't do that. I think I would like to highlight upon our ophthalmic colleagues to start the process of maintaining a medico-legal register. And with this, we move on to our panel discussion. Dr. Satyan, any comments?
Sir, yes, sir. One other point is CCTV, as Senthil sir mentioned. CCTV has to be installed in every corner of the hospital, including your consultation room. This I learned it after encountering a lot of other crisis in our IMA circle. So you have to have ophthalmology is nothing personal, sir. It is about seeing the eye, then the way you set very close to the patient, you have to be having a CCTV camera, and it safeguards you rather than having anything personal. So one is CCTV. Second is, as when there is a complaint, as you said, listen politely and respond politely. That is the way to go. And I have a question to Sendil sir.
Yes, sir.
Is staff writing a prescription and doctor signing is acceptable, sir?
No, sir. Because like sometimes it goes like who has written the prescription and whether the doctor has seen that or not. When it comes to court of law, whether the prescription was written by the doctor, that comes into an that is an
Yeah,
question.
I have seen few of the prescriptions, handwritten prescriptions, where the medicine is written in blue or whichever in a shade of color, and doctor would have signed in a black or a blue or something like that. So obviously it shows that the doctor has not written the prescription. It is written by somebody else. So is it allowed in court of law? Let the listeners understand this perspective also.
And I would like to say one more thing, sir. Recently, I went to an local district headquarters court for giving an expert witness. And I was about to give that in writing to the court. The judge suddenly intervened and he was telling, sir, don't write like your prescription. I want it to be, I want it to be legible. So that is the common thinking of an people that doctors don't write it legibly. So that's why NMC has given guidelines, and Medical Council has given a guideline that this has to be, especially when it is handwritten, it has to be in capitals and all other things. Over a period of time, getting an this thing software for this thing will be more beneficial.
I think my sincere advice to all of our members and practitioners is that slowly move towards the EMR, and it's going to become the norm in a few years' time. I think this suggestion has come even earlier that we must move to digitalization, and have digital records, have EMRs, have printed prescriptions. It is not very expensive, and I think we should move towards printed prescriptions so that it reduces error, and you can also retrieve your records, and the signature problems and writing problems do not crop up. And what is your suggestion, Dr. Nirmal?
Yeah, thanks, Murli. I think it was a wonderful series of talks on medico-legal matters. It's not only medico-legal. I think we have to say that this is practice-related matters for everybody. So whether you are in an institution or in a private practice, so it is common for everybody. And about the prescription, high time we change because NMC or even Medical Council during their days, they were focusing on this etiquettes of prescription. So right, Sendil said the important parameters of prescription, and along with that, writing in capital letters and signing. So prescription is a document. It is a you are going to give to the patient that has to be clear, legible, and patient should be able to understand it. And the third party. So here we have to consider the third parties are not only patients, the patient attenders, the pharma people who are going to prescribe that, the nursing people who are going to dispense it, and in case if the case goes to the court, the lawyers and the law enforcing authorities who are going to deal with it. So our prescription is no more a two-party affair. So our prescription is a multi-stakeholder affair. So you have to ensure that the other stakeholders understand the prescription. So this is the important guidelines that was considered when NMC came with this type of issues. And this is also going to be 100% like 100% cashless. It's going to be 100% EMR prescription in the years to come. So that is what the ABDM, the digitalization of healthcare network, is going to focus. And now with so many insurers and aggregators and everybody catching the electronic bandwagon, it's high time we take the initiative and convert to electronic prescriptions.
Thank you, Nirmal. And I now I have a question for Dr. Ravi Shankar, a comment rather. I think you mentioned about the professional conduct review, which is the new archives which has come out from the NMC. Are you there, sir? Yes, sir.
Yeah,
So,
yeah, I'm here. I'm here.
yes, sir. Could you just briefly tell us something about this professional conduct review and the lessons from the case archives which the NMC has given? Maybe you could tell us a few anecdotes and case examples from the review for the benefit of our members.
Yeah, thank you, Murli sir. In fact, I was doing this for the IMA for the last 4-5 years. Then earlier, Institute of Medicine and Law were the one who gave me the guidelines on how to give this. I think somewhere Medical Council have taken it, NMC has taken it, and all cases earlier that has been gone in the court, they have taken it as an example. In fact, I have not really gone through each case. Or 8 cases has been given of late. Every court judgments is a lesson for us because we don't have certain law in our profession to guideline. So, in fact, I have not really read individual case laws. I have to be very clear about it. Certain cases which were not related to ophthalmology, there are lots of cases which I have done it earlier. And what NMC has given, I think we will send it all to everybody. Every case, what is the law that is there in that case, which we need to adopt. In fact, all the prescriptions, whatever Medical Council have now taken up, the illegible prescription judgment has been pronounced in the National Forum Supreme Court. That only had made the Medical Council to change the law to enforce us to have a proper prescription. There had been judgments which said that it is better that the medical profession computerize their prescriptions and their EMR. All these things have come only with the earlier judgments that has been pronounced, and now Medical Council has taken 8 judgments and they have given lessons from the 8 judgments. I think we will have to share it already. TNOA Medico-legal wing has already have it, and I think we will have to give it.
Yes, sir. We will share it, sir. I think I will share the soft copy and.
Yeah. Sure.
Yes, sir. I have a question and a comment for Dr. Sujata Mohan, our Vice President who is here. She's here. Sujata?
No. No, Murli.
No, okay. Dr. Sriram Gopal? Sriram, are you there?
No.
I just wanted his comments, or anybody else in the panel also can join in and comment about the biosimilars. We are all using biosimilars, and I think Dr. Sriram has the largest experience with regards to using biosimilars. There's something like generics, but the biosimilars are slightly different as compared to generics. So what is the perception about biosimilars? We are having a huge cost difference between the innovator drug as well as the biosimilars. I thought Sriram could tell us something about the biosimilars which we are encountering. Every company now joined the bandwagon of putting in a biosimilar. So we'll find somebody who's an innovator drug, which is about say 20,000, 30,000 rupees. We now have something available for 1/3 to 1/2 of the cost. So I think we need to understand quality issues, that inflammation can occur after that. Again, make sure the patient has understood that we're using a drug which is not exactly the innovator drug. So this again comes back to informed consent. So I thought Sriram could share some insights about that if he's available. Otherwise, we will actually move on to further discussion on this professional conduct and review. We have discussed various aspects of consent, which is extremely important. We discussed the doctor-farmer relationship, and maybe we could invite comments from the panel, Dr. Ravi Shankar, Dr. Nirmal, and Dr. Madhavan, of course, about the doctor-farmer relationship. Do you see a change in the way conferences are going to be conducted in the future? Can we have a hall in which we have a background screen which tells us sponsored by Sun Pharma, sponsored by Cipla, and so on? So what is the what do you think is the future of our conferences? Should we start shelling out our own out-of-pocket expenditure for the conference, or should we still expect pharma to support us for lunch, breakfast, and dinner? I'll start with Dr. Nirmal.
Okay. So we are not going to carry on with the same practices what we've been doing for so many decades now. So we have to earn our own bread, and we have to spend for our bread. So asking for support and sponsorship, it's going to be difficult for many reasons. one, the income tax norms, because the income tax as such is not accepting any expenditure given by the farmer. It is being rigidly audited. The second is the share pharma has been allotting for these supports and sponsorship is coming down because their margins have dwindled in terms of inflation, as well as a lot of regulatory cost attached. And third, most of the MNCs, you would agree, they have rigid regulatory requirements as far as sponsorship goes, basically because of the income tax regulations. And fourth, there's a renewed thinking that instead of supporting associations, they can directly reach out to the doctors and educate them, as well as over the counter. So you can see the MNCs and drug companies directly advertising their products. So these are things that has been changing since COVID, since the electronic communications become cheaper, and with a lot of social media and IT bandwidth with the companies, they are more towards direct to marketing than through the doctors association.
Dr. Ravi Shankar and Dr. Madhavan.
Madhavan sir, you finish it off.
Yeah.
I want
Yes,
my
sir.
opinion. I will still request. They keep talking about corporate social responsibility. What is the NMC's role on educating us? Are they taking effort to educate us or update us? When they are not taking that effort, then it is left to the pharma. I don't want in lakhs and crores of rupees to be funded to the doctor or association, but association cannot run on the doctor's money alone and cannot have CMEs and all these programs. We'll all be restricted only to this Zoom meeting, Microsoft meeting. Then Zoom will start charging for every talk, every minute, every person coming online. You know the IT industry. They design a product and then charge it on man hours. And that man hours, they are enumerating for the next decade or 2 decades. You know the insurance company. We are suffering because of that insurance company paying 30% for the agent. It is 30% for health insurance. It is 30% for every insurance. You know, Life Insurance Corporation Development Officer gets a chunk of money from the premium that is paid by the clientele. The clientele is paying money to the Life Insurance Corporation. Life Insurance Corporation is paying salary plus a part of the premium to the development officer. And then corporate social responsibility for all the industry. If the pharma industry is not going to sponsor any of the conference, are they going to scale down the rates by more than 40%? You ask them what is the money they are going to spend. They are spending on the marketing, on the salary for the medical reps, or the salary for maintaining the website and all these things. If they are going to be restricted and that is going to come down, the cost is going to come down, then it is worth it. But then you will not neither do that. You will neither allow them to pay us the money. I don't want lakhs and lakhs of money, at least money to sponsor a talk. That should be there. NMC cannot go and they have a law where they can pull down the quacks. But have they done any single quack? Have they come in and then defended us in the Ram Babe case? All these laws are there only in paper, but they have never been implemented. But only for the medical community and for the medical association, they will come and trust everything on us because we are soft target in the society. There has to be a limitation. I know Cardiology Society of India is the most richest, competing with the RSSDA because diabetes and cardiac products are the one that is being prescribed in volumes and volumes. I don't want that way, but at least corporate social responsibility has to be defined, and pharma also will have to be given a guideline how they have to sponsor for an educative purpose. I think that is the way. There is a clause that the wives also should not receive any benefit from the pharma industry. Then they will start having wives in plural to get money. See, that if there is a law, there is always in between the law, there are always something inside of the law. And if the law has to be implemented practically, it has been thought practically and implemented. If that is so, corporate social responsibility should be out of the Indian economics. This is my view, Murali sir, and that is my view, Mundarmal.
Thank you, sir. Thank you, sir. I think you've really hit the nail on the head. So I think we really have to understand so many things in this very complex pharma relationship and industry and all that. But I think let us be clear in our profession with regards to our own integrity and keeping things clean and overboard. And I think focus on our own subspecialty and profession and the specialty in which we are practicing. I think we are almost at the end of our allotted time for the webinar today. And any other comments, Dr. Satyan, anyone else who would like to make a comment with regards to the entire webinar which is going on now? Satyan?
I'm being the TNMC observer, sir, for CME programs. The pharma companies are not allowed to keep banners or any flex inside the hall or where the academic event is going on. So even the pharma companies are finding it difficult to display their banners in the trade area, like where they provide additional beverages to the participants or the delegates. So pharmas also are aware about the tightening which is happening by the NMC regarding CMAs or conferences. So we will be having a lot of tough, because there is no clarity regarding what has to be done and what cannot be done. So things should be clear before it gets cleared. Association should be actively deliberating what is good for us in an active way, both from IMA side, from respective specialty associations.
Yeah, I would like to end this session with a brief comment about to our members, with a brief about problems which they face in their practice, be it in their day-to-day practice, be it receiving a notice, signing a contract, or anything else with aspects to the law and understanding the health laws applicable to our practice. We have now come out with a two-part review article, which is one part has already been published in the TNOA journal last issue, and the next one is coming up in the next issue, which is very, it actually has a very detailed way of dealing with various aspects of ophthalmic practice, medico-legal aspects of ophthalmic practice. The second is any communication with regards to their problems, litigation, responses, and anything else with regards to notices can be sent to the TNOA secretary by an email or any other communication, and give us a little time to respond and help you out with the response to this kind of notices. And do not expect that we're going to give you a legal kind of an opinion. We're going to give an advisory opinion, and give us a little time to respond to that. So we'll give you a communication channel which you can communicate to us with regards to how we can help you out. But do not panic and do not respond like a knee-jerk instant reaction. Give a little time. There is always a little time for us to think out a response and respond in a proper manner and so on. And I think I saw Dr. Sriram has come in, and I would like to take his help with regards to
yes,
this.
Sorry, I had to go offline in between.
Yeah, just to bring
there was
you
a
into the
question to
picture
you,
about communication.
Sriram.
Okay, sir. What was the question?
Yeah, the question was regards to the your experience with the biosimilars as compared to the generics. So, how do you see and foresee the usage of biosimilars? Was my question. And the second, of course, is to keep you involved about information and queries and questions that can come into you from TNOA members. So we're going to keep an open communication channel which you could receive and help the members respond to any legal notices and summons and so on.
Yes, sir.
First about the biosimilars.
First question regarding biosimilars. Well, two aspects. If you're asking about the clinical aspect of it, well, I've tried out, I've been one biosimilar, I don't want to use names, but one biosimilar I've been using for quite a number of years as far as anti-VEGF goes. The safety profile and efficacy is good. Couple of other newer biosimilars I've used. So far, I have not used in large numbers, but they are pretty okay, and I have not had any issues. And This is a clinical aspect. But practically, I am a little wary of trying more and more newer biosimilars because of the obvious risks involved. So whatever I do, I always start in a very small numbers. Being a VR surgeon, I have the luxury of using it initially only in my pre-op patients. So even if there's an issue, I'm always going to do a surgery to bail them out. Medico-legal aspect, I don't know. You should probably clarify this because people are now talking about having separate consents for a original molecule and a separate consent for a biosimilar. I would actually like your input whether that is really necessary, because all drugs which we use are authorized by the DCGI.
Yeah, the informed consent actually has to include this information saying that the drug which is being used is so and so, and the drug which I am planning to use for your ailment in your eye is going to be a biosimilar, and the risk and complications, consequences of using and not using, all of this has to be highlighted. And probably you should give them a little time. So what I now started doing in our practices in the 2-3 centers where I visit is try to get the informed consent at least a few days prior to the surgery itself. You don't really have to get it on the morning of surgery. So that gives a little time and patients are also able to understand. And you can always tell in any kind of issue that comes up later on for litigation that you have actually informed the patient several days ahead of the procedure. You don't really have to sign it 15 minutes before the procedure. Yes, Satyan, yes, Satyan.
Sir, even when we had a thing of translating English to Tamil, we have a separate consent for Rasumab. We have a separate consent for Macugen.
Yes.
So, Sriram sir, that book has a separate consent for each drug. Probably we might need a
Satyan,
biosimilar zone.
Macugen and Rasumab are different drugs. I'm
That
not
is
talking
right,
about
sir.
different
But
drugs.
intravitreal
I'm
as
talking
such,
about I am talking about the same molecule.
Biosimilar.
Same molecule.
Biosimilars.
From
Probably
different
we need a
companies.
yes.
From different companies.
So previously we had
same molecule
one
from
consent
different
for
companies.
intravitreal. Every intravitreal we had a one consent.
No, that is not acceptable. That is not acceptable. What I'm talking is, see, to be very frank, the so-called ranibizumab from Novartis, which you're using, is not the original molecule. You try getting a letter from Novartis saying that Lucentis and Macugen are the same molecules under different brand names, you will never be able to.
They will not give.
It is from a different, to be frank, off the record, it's from a different cell line. They will never give that letter.
Okay, let me add some clarity to this.
Yes, sir.
Because consent for generics or original items. So one important aspect is doctors should educate patient about generics, explaining that they are equivalent in efficacy and safety to the original. So this is part of the consent for any drug which has original as well as biogenerics. And the communication has to be documented that there is a benefit of the original item, and that has been explained to the patient. Because in case the patient claims that they have not got the benefit of the drug and claim that if the doctor has told us that the benefit will be less compared to the original molecule, we could have taken the original molecule irrespective of the cost. So this has to be discussed with the patient and documented in the consent. And the change in even 1% of the molecule, whether additive or preservative, also has to be discussed with the patient. And that has to be incorporated in the consent. So this is the few lines that are in tune with the biogenerics and biosimilars as well.
Thank you, Nirmal, and thank you all for joining in and staying for the 1.5 to 2 hours of the intensive. It didn't look like we were spending so much of time. I think we have crossed 2 hours.
Yeah.
And, it was very absorbing interest. I'm getting a lot of messages from members about the content and the interesting nature of the discussions and so on. We'll take it forward with the TNOA's help, and the help of our secretary. We will communicate to all members regarding various aspects of safe practice, being safe and preventing litigation. Like so many aspects which we discussed today, we'll summarize it for you and put it across. And Dr. Ravi Shankar's inputs about the NMC as well as various aspects of the professional conduct review and so on. All of this we will bring it forward and put it in a nutshell for easy digestion for all of our members. So final comments from Dr. Satyan.
Listen, nothing, sir.
Final
Done.
thanks. So I think with this we come to the TNOA management, the TNOA executives who are all present today, and I can assure you that you can look forward to more of these kind of communications from the medico-legal committee and our team. And I'm supported by Madhavan, Satyan, Sendil, and so many other advisors in our team. We have a wonderful team, and we've all been learning at the same time, able to communicate. We hope to take this forward. Thank you again, and thank you one and all. I also request maybe a vote of thanks from Satyan.
Yes, sir.
Yeah.
Yes, sir. I thank all the speakers and the panelists who've been here, especially Dr. T.N. Ravishankar sir, Dr. Murli sir, who is the chairman of Medical Legal Committee, and Dr. Sendil sir, Dr. Madhavan sir, and especially thank our president, Dr. Nirmal sir, for initiating this various committees and making sure that we deliver these ideas to our fellow practitioners. And I also thank Dr. Sujata madam for being here, and I also thank our secretary, Dr. Sriram Gopal, and other managing committee members. And I also thank the ClearNet for connecting us through Zoom and YouTube. And I hope this gave you a lot of knowledge about issues with medical legal cases and what you have to do regarding to safeguard yourself. I thank one and all for being here. Thank you, sir. Thank you all.
Thank you all. Thank you, Satyan.
sir.
Thank you, Murli. And thank you all the speakers for the wonderful effort. So we will be posting the link in TNOA website as well as to all our members. So I hope this is a useful initiative. Thank you.
Thank you, sir. Thank you, Melissa. Thank you.
Thank you, everyone.
Thank you, Garner team.
Thank you, Satyan sir, for your kind words, and it really means a lot to us. And thank you so much, everyone, for extending us the opportunity to host the session today. I hope you all had a seamless experience. With all your due permission, we are concluding the session over here, and really looking forward to hosting you all again. Thank you so much, and bye. Good night to all of you.
Good night.